Okay, there's two questions when we talk about this question of divorce and inheritance. Divorce and inheritance. First of all, if you have inherited property, it's really important to make sure that that property is earmarked as inherited property and is a separate property and belongs to you. And when we structure asset protection, there are plenty of ways in all of these entities to make sure that you identify that that property was a property specifically not considered to be married property or married assets. Having said that, you should be able to protect inheritances from a divorce, etc. However, when it comes to all other kinds of acquisition of properties after a marriage has occurred, it is important to know that there are really two areas that come up in common life every day about viewing asset protection, where asset protection is not going to protect you. One is bankruptcy, and that is because all structuring that we normally do is state statute sensitive. They're made by state statutes. Bankruptcy is federal, and federal cases can preempt state statutes. So bankruptcies are not going to be protected. Bankruptcies do not protect assets inside of limited partnerships and LLCs. And the same thing applies to divorce. Long before we had these entities being able to be set up, we had divorce and we had bankruptcy. So when the various states put together these statutes allowing LLCs and limited partnerships to exist, they recognized that they didn't want this to be used as a shield for one spouse to defraud the other spouse in the event of a divorce. So when divorce occurs, the judge is simply going to require all these assets be separated. The exception to that would be inherited property that was properly structured beforehand, so it will not be considered to be common property as far as the marriage is concerned.